A president signed a law she said she had concerns about. That sentence should stop you. Not because it is unusual in the long history of constitutional theater, but because of exactly what she said before she signed it, and precisely what that choice now means for every person who will be processed under this law from the 12th of June, 2026. The International Protection Bill 2026 is now the law of Ireland. President Catherine Connolly signed it on the 22nd of April. She did not refer it to the Supreme Court, despite convening the Council of State to examine it, the first such convening of her presidency. The statement from Áras and Uachtaráin was careful to say that her concerns about the constitutionality of the bill remain. They remain. She signed it anyway. There is a version of this story being told inside Leinster House, and there is the version available to the rest of us. They are not entirely the same version. That gap between what the official framing says happened and what the constitutional mechanics actually produced is where this story lives. Before we go any further, drop the city you are watching from in the comments and tell me how much time you have right now. Are you on a quick break or settling in? I am genuinely curious where in Ireland, or elsewhere, people are watching this one, because this particular story touches on something that goes well beyond Dublin politics. Now, here's where the story takes a turn. The Council of State met on the 20th of April in what government sources described as an intense session. That word, intense, was used more than once by people who were in the room or close to it. Intense enough that the full deliberations were not made public. Intense enough that the president took 2 full days before issuing her decision. And when that decision came, on the 22nd of April, the statement from Áras and Uachtaráin contained a phrase that should be read with some care. The concerns that led to the president calling a meeting of the Council of State remain. She was not saying the concerns had been resolved. She was not saying the bill had been improved. She was saying, I still have concerns, and I am signing it. That is not a contradiction. It is a constitutional calculation. And to understand why, you need to understand the specific trap built into Article 26 of Uachtaráin, the provision that makes presidential referrals both powerful and permanently double-edged. Under Article 26, the president may refer any bill to the Supreme Court before signing it. The court then decides whether the legislation is constitutional. If the court finds it is not, the bill is dead. But if the court finds it is constitutional, and this is the critical part, no court can ever question that legislation again. Not now, not in 10 years. A specific individual walks into a detention facility under its provisions and challenges them on the basis of their actual experience. The legislation is permanently ring-fenced. Article 34.3 of the Constitution is explicit on this. The President cited it directly in her statement. So the choice Connolly faced was not simply sign or refer. The choice was sign and preserve the litigation window for future challengers on factual grounds, or refer to the Supreme Court and risk permanently closing that window if the court upholds the law in the abstract. None of that, however, is the full issue. The full issue is what this law actually does, and why a sitting president found it serious enough to convene a constitutional advisory body she had not used at any point in her presidency before this moment. The International Protection Bill 2026 is, in the government's own framing, the most significant reform of asylum law in the history of the state. That is not a figure of speech. That is Minister for Justice Jim O'Callaghan's description, offered on the day of signing. The legislation overhauls the entire process by which people seeking international protection in Ireland are assessed, documented, and in some circumstances detained. From the 12th of June 2026, every person arriving in Ireland to seek protection will undergo mandatory screening, identity checks, biometric enrollment in the Eurodac database, a European-wide fingerprint and facial image system, health assessments, vulnerability assessments, fast-track channeling for claims deemed manifestly unfounded or inadmissible. New biometric e-gates are due at Dublin Airport Terminal 1 by August. The system is designed to be comprehensive, front-loaded, and fast. The government's argument is straightforward. If you process people faster, you reduce backlogs, provide earlier clarity to applicants, and reduce the limbo that has defined the Irish system for years. That argument has genuine force. The backlogs are real. The delays have been damaging. The current system is not working well for anyone. Not for applicants, not for the state, not for communities trying to absorb large numbers of people with no resolved status. But here is where the story takes a turn. The Irish Human Rights and Equality Commission, an independent statutory body, not a campaign group, raised specific concerns about the detention provisions. So did a range of NGOs that work directly with asylum seekers in Ireland. Their concern was not with faster processing in principle. Their concern was with what happens to people during that processing, specifically, the expanded powers to detain individuals during screening, and whether those powers are compatible with Ireland's obligations under international law and the European Convention on Human Rights. These concerns did not emerge after the bill was signed. They were raised during the Oireachtas debate. The bill passed anyway. They were raised again by members of the Council of State. The President signed anyway. An independent monitoring mechanism, introduced following lobbying from civil society, will audit age assessment and detention practices. That monitoring mechanism is now written into the law, which suggests the concerns were considered serious enough to require oversight, without being considered serious enough to stop the bill, which is, technically, the design, which is, technically, the problem. Everything we have just covered, that is one layer of the story. The layer that sits underneath it is not about domestic politics at all. It is about where this law came from, and why Ireland had almost no choice but to pass it by the 12th of June, regardless of what the Council of State thought. The European Union Migration and Asylum Pact. Ireland signed up to it in 2024. The pact sets a union-wide framework for how member states handle people seeking protection. Standardized screening, standardized documentation, standardized timelines. The deadline for implementation across all 27 member states is the 12th of June 2026. That date did not move. It was not negotiable. Ireland did not have the option of saying, we will implement this in September when we have had more time to debate the detention clauses. 27 seats at that table in Brussels. One of them is Ireland's. The pact was agreed. The deadline was set. The legislation had to be drafted, passed, and signed within the window, and the window closed on the 22nd of April. The tension here is not unique to Ireland. Hungary, Poland, and Slovakia have pushed back against the Migration Pact on explicitly sovereign grounds. The argument that it diminishes their national capacity to control how many people can seek protection within their borders. Ireland's friction was different in character. It was not a challenge to the pact from the right, demanding less processing and fewer arrivals. It was a challenge from the constitutional and human rights space, arguing that the specific mechanisms chosen to implement the pact may not survive scrutiny under Irish law. Same architecture, different fault line. If this kind of breakdown, the mechanics behind the headline, the constitutional tension underneath the official announcement, is what has been missing from your feed, you know what to do. Now, back to the numbers. The speed at which this legislation moved through the Oireachtas deserves a closer look. Opposition parties objected not only to specific provisions, but to the pace. The bill was pushed through in a matter of weeks. That pace was a function of the EU deadline, not a function of urgency created by a domestic crisis. The government needed the law operational by June. The Oireachtas calendar compressed accordingly. The Council of State deliberated intensely for one session. The President decided within 2 days. Former President Michael D. Higgins convened the Council of State 4 times during his tenure on Article 26 questions. He referred one bill. The Supreme Court found it to be constitutional. That bill's provisions were then permanently beyond challenge. That history is directly relevant to what Connolly did on the 22nd of April. She had a precedent that showed referral is not a neutral act. It is a gamble on the abstract constitutionality of language that has not yet been applied to a real person in a real situation. And if you lose that gamble, if the court upholds the law, you have handed the government a permanent shield against future litigation, at exactly the moment when the law's application to vulnerable individuals is the thing most worth scrutinizing. The President's statement made this logic explicit. She noted that Article 34.3 provides that no court can question the validity of any legislation deemed constitutional following a referral. In that context, her statement said, "The capacity of a person wishing to bring a future legal challenge on the basis of real facts, rather than abstract constitutional argument, has to be taken into account." In plain English, she kept the door open for the people who will actually be affected by this law to walk through it, on their own terms, with their own facts, in their own time. But all of that is still at the level of legal architecture. Here is what it actually means on the ground. From the 12th of June, the experience of arriving in Ireland to seek protection changes. Not in theory, in practice. At the airport, at the port, at the registration office. The mandatory screening regime is not optional. The biometric enrollment is not optional. The fast-track assessment for inadmissible claims is not optional. For the vast majority of applicants whose claims are straightforward, the government's position is that this will mean faster decisions and less waiting. For those whose claims are complex, or who fall into the categories flagged by human rights bodies, those subject to detention during screening, the framework is now law, and the monitoring mechanism is the primary safeguard. For Irish society more broadly, this law is the point at which Ireland formally and structurally joined the EU's common asylum processing architecture. That is a significant shift in how the state manages migration, and it will not be invisible. Dublin Airport's Terminal 1 will have new biometric infrastructure by August. The HSE will be required to conduct health and vulnerability assessments as part of the screening process. The courts will, at some point, receive the first challenge to a detention decision made under the new provisions. And that challenge, when it comes, will not be abstract. It will be specific. It will be about a named individual, a documented detention, a measurable number of days. It will be the kind of case the President's statement was designed to preserve the possibility of. Whether the law survives that challenge, or whether the human rights concerns raised by the Irish Human Rights and Equality Commission turn out to be well-founded in practice, will not be known on the 12th of June. It will be known later. Ireland is a small country with a long history of being shaped by external frameworks it did not entirely design. From the terms of EU accession to the conditions of the Troika years to the architecture of the Good Friday Agreement. The Migration Pact is the latest such framework. The International Protection Bill is Ireland's domestic translation of it. The constitutional friction that surrounded its passage is a signal, not a footnote. It tells you that the people closest to the text of the law, the President, the Council of State, the human rights bodies, saw something in it that required serious deliberation, not rubber stamping. That is worth holding. Not as a reason to oppose the law or support it, as a reason to watch what happens next, closely. The 12th of June is the activation date. The courts are the next arena. And the monitoring mechanism that civil society lobbied hard enough to write into the legislation is either a meaningful safeguard or a procedural gesture. We will find out which.